In the first full day of hearings of a petition that is challenging President Uhuru Kenyatta's re-election, lawyers for the petitioners clashed with defense team on the legal and political environment surrounding the poll and the subsequent results. Our team, make that our top team of Francis Kashuri and Sam Gituku, have been following the proceedings all day long. Gentlemen, good evening. What's the latest?
Jeff Kwenange, good evening to you. Day 9 of the 14 days the Supreme Court judges have to hear and determine the petitions that have been submitted by Helef Khalifa and John Jomue, as well as John Harun Mwau, the former Kilome Member of Parliament. And the submissions have been made, and as you briefly outlined there, the petitioners put their case before the judges, and the common ground is that they are seeking the annulment of the presidential election conducted last month on the 26th, as ordered by the Supreme Court on the 1st of September, when the judges nullified by a majority ruling the election that was conducted on August 8th and forced President Uhuru Kenyatta and others to go back to the ballot for the repeat presidential election. And John Harun Mwau, the former Kilome Member of Parliament, was arguing that the judges ordered a fresh presidential election, and so that election should have been conducted in the very sense of that word, fresh, meaning fresh nominations and an entire process from the scratch. And so they were arguing that IEBC erred in law by failing to conduct fresh nominations when they conducted that election on the 26th. And secondly, when NASA leader Raila Odinga withdrew from the race on the 10th of October, then IEBC, according to the petitioners, should have cancelled that election and ordered a fresh nomination. So if NASA wanted to field another team of candidates, then they should have had an opportunity to do so. And that IEBC did not do the correct thing by conducting that election even after the NASA leader withdrew from the race. And Helef Khalifa and John Jomue, the argument is that the judges on September 1st had ordered that the election be conducted in strict compliance with the Constitution and the applicable election laws. And according to John Jomue and Helef Khalifa, through their lawyers, Julie Soweto and Harun Dubi, they argue that IEBC did not do exactly that, and that the infighting within the commission between the commissioners and the secretariat marred the independence of the commission, and as it were, made it unable to conduct a free, fair and credible election. And also the question of the constituencies where the election was not conducted. About 26 of the constituencies in Kisumu, Siaya, Migori and Homa Bay counties in the Nyanza region. And though the petitioners were insisting that Article 138(2) of the Constitution insists that a fresh presidential election or a presidential election should be conducted in all the constituencies. And the petitioners' case is that the environment was poisoned, the mood was not right to conduct a free, fair election, and that the judges should order for a fresh poll that will have a climate that will enable every person, every Kenyan to exercise their democratic right. And of course, the IEBC team had an opportunity to respond to those allegations, and that's why Sam Gituku is here.
That's right, Francis. And Jeff, as far as the question of whether the withdrawal of Raila Odinga should have effected that fresh nominations be conducted, the IEBC team is saying that it was not done in accordance with the law, and the law says that you have to fill that form 24A for you to be allowed to withdraw from the race, and that was not done. And they're also saying that because the withdrawal by NASA was on the 10th of October, there is a court ruling by the High Court on the 11th of October that indicated that the other candidates, that is talking about Kuro Court and the other 5 candidates being included in the race. So IEBC is arguing that they were working with the guidelines that had been given by the courts, and so they were just following the law because they had to conduct an election with the candidates as ordered to be included in the race. The other question by the petitioners, that is John Jomue and Helef Khalifa, who are saying that there was no universal suffrage in a sense that not everyone registered to vote participated in the election, because they were saying that that the voter turnout was about 38% compared to August, when the voter turnout was 79%. So the IEBC is saying that for them it was to prepare for that election, and so the polling materials were prepared. They were transported to the polling stations, but there was difficulty to transport those materials to the 25 constituencies that my colleague Francis referred to. And so it is not the blame. It is not IEBC to be blamed, because they are saying there is a letter that we hear of for the first time that was written by the PAs in the Interior Department on the 27th of October, indicating that the ground was not right for holding of an election on the 28th of October. That is the postponed election that was to be conducted in the counties of Nyanza. And so IEBC is saying that based on that strength, they could not go ahead to conduct that election in those areas. And so the judges were asking, when you postpone an election, what are you saying? Are you postponing indefinitely, or should you cancel the election? And so the lawyers representing IEBC, specifically Karori Kamau, or rather Kamau Karori, was saying that it is up to the judges to decide, should they cancel or should they postpone indefinitely. But based on the strength that is contained in regulation, or rather in section 55B of the Elections Act, then they had the power to postpone that election, and also to proceed on to declare the election based on the constituencies that had participated. And so it has been that submission from the IEBC saying that they did what they could in their power, and so it is up to the judges to determine, are they convinced by the cases advanced before them by the petitioners, or is the evidence tabled by IEBC convincing, so that they can be in a position to really determine the outcome of this particular petition, Jeff.
It's okay, Sam and Francis, correct me if I'm wrong, but talk to me about this. Is there less grandstanding in the Supreme Court than we saw in the other petition back in late August, early September? Is there less grandstanding this time around?
Jeff, I would say there's less political activity within the courtroom and outside the courtroom as compared to what we saw in August. And when you look even at the attendance, there were very many politicians who were attending the courtroom sessions in the August presidential election petition. But the situation is slightly different now. More or less, you see a lot of sound legal arguments that are being made by lawyers representing the petitioners and representing the respondents. Is more of a game of wits on matters of law than a lot of political grandstanding. So yes, you can say there are more constitutional issues that the judges have to deal with in terms of the petition, rather than the many political issues that we saw canvassed in the last presidential petition, Sam.
And actually, Jeff, if you look at the conduct of the judges, you realize that this time round there is more of the engagement by the judges in terms of putting the lawyers who are presenting their cases to task to explain what is the converse of the arguments that they are tabling before the court. Because, for instance, when the lawyers for the petitioners said that there was no universal suffrage, they are asking the question, when you say that everyone has a right to vote, how about the right not to vote? So that is a question that the petitioners have to answer, because it has to be measured based on those who voted and also those who did not vote, because they were exercising their right. So it's a question of the judges getting to be involved. And actually yesterday, when you listen to the Chief Justice, he was putting to task some of the people who are making applications before the court, saying that he himself participated in the election when he went to vote in Nyamira County, and he saw that the physical voters register was available against the claim that had been made by some of the applicants before the court represented the petitioners, Jeff.
All right, Sam Gituku, Francis Kishuri, great job first day. Keep up the